My name is Dwayne Quasey Wright. I'm an assistant professor of higher education administration here at the Graduate School of Education and Human Development, which is part of the George Washington University. And this is our last DEI event of the calendar year. This is our What Do We Mean By series, where we take a topic, we have an expert, we demystify it. We usually have a topic squarely in education, and this is solely squarely in education, but we wanted to reach out and sort of expand our bounds this evening. Much has changed in the realm of college sports over the last 10 years. The folks that may be from Texas know that we have a college playoff. Not everyone's very excited about how that goes in. Many of you know that the vast majority of our athletes are not in the so-called revenue-generating sports. When I went to college in the yesteryears of 2007, 2011, we were amateurs and we could not accept any type of remediation during college. In fact, if a recruiter bought us a soda, we had to do it hush hush. That has changed. And the reason that has changed is an installment of something called name, image, and likeness. And to teach us about that today, we have an expert here for you. This is Professor Mitch Crusto. I call him affectionately just Mitch. Mitch has a stellar record. He graduated from Yale undergrad, had another from Oxford as a Marshall Scholar, and then went on to graduate from Yale Law School. Very humble guy, but I want to sing his praises. He's published numerous, books and articles, and the one that is here today is Game Changers: How Name, Image, and Likeness Creates College Millionaires. And we will put that. It was published from the American Bar Association Publishing. We'll put the link here in the chat. Just a few more things that Mitch has done before we let him take away. His essay, A Plea for Affirmative Action, was published in the Harvard Law Review Forum in January 2023 and was featured on CBS Sunday morning. He has had several national media appearances. His book on civil liberties and disasters, Involuntary Heroes, was a finalist for the American Bar Association's Silver Gavel Book Award. And for those not in the legal academy, that's a pretty big deal. Professor Crusto has clerked for John Minor Wisdom, very, very, very famous judge for the appellate clerk for the Fifth Circuit, and served on two U.S. presidents in their government policies and positions. If I could take just a brief moment of personal privilege and say that Mitch is really a good mentor to many of us trying to get in legal academy. He has mentored several men of color to try to get in there. And in this era where folks are retreating, maybe strategically from values that they professed during the summer of 2020 to be so close to them, Mitch is someone that walks the walk and continues to talk the talk. And for that, I really appreciate you. And I'm honored to call you a friend. Professor Crusto, please tell us, what do you mean by name, image, and likeness?
Great. Well, thank you, Dr. Wright, for the warm and generous introduction. And thank you, those participants who are here to share this time together. I'm looking forward to sharing my thoughts about this area and getting your feedback and questions later on in this session. So as Dr. Wright said, I am a law professor, Mitch Crusto, a leading expert on NIL and author of Game Changers. Over the last several years, I've studied a very unique development in our society, that is the name, image, and likeness law that is creating college and high school millionaires. I'm here to explain what is NIL and why it is important. Let me give you a roadmap of my presentation so we can just move on to the next slide. It'll be great. Get a little bit of background, and then the next one is the guidelines or the roadmap. So what we're going to talk about are 9 different points of information. First of all, I'm going to share with you some examples of NIL college millionaires. A number of them are people that you have heard about, should be familiar with. Number 2 is the multi-million-dollar NIL deals. I'll describe what those look like. Number 3, what is NIL? Number 4, how does NIL work? Number 5, what are the pluses and minuses of NIL? Because it's not winning the lottery, so there's some minuses to it as well. Number 6, why is NIL a thing today? Number 7, why is NIL controversial? Number 8 is why does NIL matter? Not only for college athletes, but quite frankly, for everyone beyond just college athletes. And then number 9 is a summary of all the points. So let's get to the examples. So college millionaires, NIL millionaires, who are they? Well, these are some of them that I kind of focused on in my book in studying their NIL, what I call power secrets. Some of these names you will be familiar with. Caitlin Clark, her net worth in 2025 is $20 million. Olivia Dunn, her net worth in 2025 is $10 million. Arch Manning, who's playing for UT, his net worth presently is $6 million. Bronny James has a net worth of $5 million. Shedrew Sanders, net worth is $4 million. Angel Reese reportedly is $1.5 million, although she basically has said it's actually more than that. And number 7, Bryce Underwood is $1.3 million, which is a little bit misleading as a net worth because we're going to talk about Bryce Underwood's $10 million NIL deal. So why are these young people, relatively young people, college and recent graduates, so financially successful? Well, they're using their popularity to get paid big money for licensing their NIL to major corporations to endorse those corporations' products or services, or they're getting paid money to play their sport for a particular college. So what are their NIL power secrets? Let's kind of jump into some examples of these individual NIL millionaires. So we can move to the next slide. Thank you. So first off, let's talk about product endorsements. So one of the greatest sources of NIL millions is illustrated by Arch Manning, Texas Longhorn star quarterback and member of the famous Manning family, has NIL deals with Panini, America, and EA Sports and others. In fact, during a recent college television game showing UT playing, he actually was highlighted in a TV ad for some of the apparel products that he is promoting. Excellent athlete in a high revenue sport being college football. And not unusually, but unusual because most people don't have what he has, which is a legacy, a family name and connections, very similar to Bronny James. But as we'll see later, you don't need to be a famous named person in order to get multi-millions in NIL contracts. Reportedly, net worth is worth $6 million. You can move on to the next slide. Thank you. So a person who did not start out with a named family legacy and is not in a sport that is a high revenue sport is Olivia Dunn. Olivia is an LSU gymnast, social media influencer. She boasts about 14.4 million in followers across Instagram, TikTok, and X. And that number is even more than it is today. Her popularity has allowed her to secure lucrative endorsement deals with major brands such as L'Oreal, Valori, Forever 21, Nautica, Spotify, and YouTube. She was also featured in a Sports Illustrator magazine report on NIL. She's known for commanding extremely high rates for sponsoring posts, with reports stating that she charged over $500,000 for a single post. Her net worth is reportedly about 10 million and counting. And again, unusual because she's not a legacy. She basically is a social influencer in a sport that is not a high revenue sport, being gymnastics at LSU. We can move on to the next slide. Now, this one is an interesting one. This is another example of what's called a different type of NIL deal, which is a booster sponsored deal. Bryce Underwood. So endorsements are where basically a corporation like Nike might pay someone to endorse their sports shoes or other types of apparel. In this case, another example of multimillionaires that are being made overnight is where boosters, who basically are supporters of universities, have raised money to fund incentives to attract recruits to the university that they've attended. In this case, the University of Michigan's NIL collective called Champion Circle is at the heart of an NIL deal for Bryce Underwood. Bryce is a star quarterback for the University of Michigan. The Ellisons, founder of Oracle, one of the world's richest persons, and a University of Michigan alumnus, was the major backer of this deal. This is a $10 million deal. So basically, Bryce Underwood, not involving endorsements at this point, is going to be paid $10 million, at least contracted for over $10 million to play as a quarterback for the University of Michigan. Let's move on to the next slide. Thank you. So those are some examples of the success stories of NIL college millionaires. So that raises the question, well, what is NIL? Also referred to as name, image, and likeness. Well, NIL is a person's legal right to be paid for the use or license of a person's identity, that is, their name, image, and likeness. A person's identity includes their name, such as Caitlin Clark with Nike, their image, like for their photographs, likeness, or visual representations, and other likeness like the characteristics, signature, voice, and other unique identifiers. The first type is the one we saw relative to Manning, which is an endorsement deal. He's not the only one that's gotten endorsement deals. Again, another example is for social media activity is a number of the multimillionaires on the list. But an endorsement deal, you basically are endorsing products or services. You might be using your social media following to monetize sales and promotions, merchandising, and other personal business ventures. The second type are what we call boosters, which is one we saw relative to Bryce with the University of Michigan. These involve collectives of college boosters who raise money to incentivize a player to play for their college team, such as we said with Bryce Underwood. The third type is relatively new. There was a major lawsuit relative to the NIL with the NCAA called the House case. It was basically a $3.8 billion claim. The NCAA settled the case for $2.8 billion. And as part of that settlement, the NCAA and its member colleges can now pay players for playing directly for a particular college, which previously had been a violation of NCAA rules. So the question is, how much does a person get paid? Depends on their popularity or their athletic performance. And while there are NIL millionaires, the average NIL deal is only $20,000, which is not bad. I mean, $20,000 for someone, basically to do an endorsement or to show up in a sports camp is pretty good. So not everyone is making multi-millions with NIL. NIL is available for other levels of athletes who can also get paid less money for their activity. Let's move on to the next slide. Thank you. So how does it work, NIL? An NIL deal begins with a letter of intent to contract. In such a letter, a company such as Nike or a collective, such as the University of Michigan's collective, would propose some basic terms to pay a player for stated duties, such as endorsing athletic gear. If the player and the offering party will negotiate the terms of an NIL contract, if there's an agreement as to the terms of a contract, the final NIL contract should be reviewed by the legal counsel of both parties. If the contract is accepted by both parties, it will then be signed by both parties. Now, if the player is a minor, which some of them are, because some of these contracts are being signed while folks are seniors in high school and maybe under the age of majority in their state, those parents may need to sign on their behalf. And here's a caveat. The deal needs to comply with NCAA, state laws, and college rules. So these contracts are very technical. They're not necessarily protective of players' rights. And so, as we'll talk about later in a minute, there are pros and cons of NIL deals that oftentimes, well, should be benefited by the player getting legal counsel. Next slide. Thank you. So what are the pros and cons of an NIL deal? Well, as I mentioned, an NIL deal is not like winning the lottery. You don't just get your money and can walk away and pocket your funds. So the pros are kind of obvious: fame and fortune, money and popularity. But there's lots of cons to an NIL deal. First of all, the law does not protect athletes from exploitative deals. In some instances, for example, you might think a company like a Nike might be a fair dealer in negotiating an NIL deal, but quite frankly, companies are oftentimes looking to benefit themselves and not necessarily looking to be fair players. And so it's very important to know that an NIL deal can result in the exploitation of a player, because in this country, freedom of contract is the rule. And the law requires you to rely on legal counsel to make sure that you're not being exploited. Number two, the deal could end with an injury. The contract could say you are going to get paid based on your actually playing the sport. And so imagine that if you're, for example, Bryce Underwood, and you have a $10 million deal, it's not unlikely that contract, which is a private contract, we haven't seen what it actually says. It could say that if Bryce is injured in the first game of the season and can't come back to play, that may terminate his $10 million deal. So you're not guaranteed unless the contract says there's a guarantee. Number three, there's potential losses of other benefits like federal Pell Grants. So if you do an NIL deal that only brings in $20,000 but disqualifies you for a federal Pell Grant for your scholarship, you're attending college, it may not be worth the trouble. NIL deals also stressful. In addition to all the things that is required for you to be a successful athlete, i.e. in practicing and playing the game, which is stressful enough, and the academic rigor of being in college, you have to maintain your social media and personal appearances and online presence, and that's very stressful. Next one is you need to become business and legal savvy, because NIL deals are technical in nature. The next one, subject to changing regulations, oversight, and compliance with state law, compliance with the NCAA rules, and compliance with your college or university regulations. And lastly is what I call family drama. When someone is potentially going to become a multimillionaire overnight, you have to be mindful that parents who usually are in your corner might shortchange the deal, might say, look, I'll take this $1 million right now, even though my son or daughter's future might be worth $10 or $20 million. And so between that and other kind of family-related issues, there are examples of family drama relative to NIL deals, which we can talk about later in the Q&A. So my advice relative to these pros and cons is to hire professional consultants, including lawyers, accountants, public relations experts, tax, investment, and real estate planning. And you might go, well, what do you mean tax? Yeah, NIL deals are taxable income. And so you have to be mindful of the impact of that income from a tax planning standpoint. Let's move on to the next slide. Thank you. So that's the background of NIL. So why is NIL such a new thing today? Well, as Dr. Wright mentioned in the introduction, prior to 2021, the NCAA prohibited college athletes from receiving any money relative to their athletic status and severely punished players for even minor violations. The person on the right side of the picture, for example, Chase Young, formerly played for the Ohio State defensive end, was suspended by the NCAA in 2019 after he accepted a loan from a family friend to help cover travel expenses for his girlfriend to attend a game, an away game where he played. This case highlighted the severity. So he was suspended for that loan. Highlights the severity of the NCAA's what's called amateurism rules and sparked debate over the fairness of restricting athlete compensation. Let's go on to the next one. But things changed in the law, particularly relative to the NCAA as it relates to antitrust law. In the O'Bannon case, O'Bannon versus NCAA in 2014, the court ruled that the NCAA's restriction on athletic compensation violated antitrust laws. The case struck down the NCAA's ban on NIL payments, but did not require schools to pay student salaries or athlete salaries. The ruling led to the removal of the college athletes from the EA sports video game until the NCAA began in 2021. It set the stage for NCAA restrictions as it relates to antitrust law. So in the next one, 2021 major case, the NCAA versus Austin, the court ruled that the NCAA restrictions on education-related benefits violated federal antitrust law. Justice Brett Kavanaugh issued a strongly worded concurrence stating that the NCAA's broader compensation limits could also violate antitrust law. Now, just to make you understand, the NCAA argued and believed wrongfully that it was exempted from antitrust laws. And as a result, it could basically restrict college athletes from any other compensation other than scholarships. The court said that's not the case. So this ruling opened the door for expanded athlete compensation, leading to NIL rule changes in 2021. Next slide, please. And then most importantly, state NIL laws were enacted as a result of the Austin and the O'Bannon case. California led the way with Senate Bill 206. First major NIL law passed in 2019, effective 2021, basically uses what is called the right of publicity, which is a tort action that says that if someone is using your image without your permission, name, image, and likeness without your permission, that's a violation of your privacy rights or the right of publicity. At any rate, this California law basically established the right of college athletes to avoid the NCAA restriction prohibition on NIL deals. And as a result of this law, other states like Florida and Texas and most of the states, almost all, basically now have state laws that protect college athletes relative to their rights to make money through NIL deals. Let's go into the next one, next slide. So NIL, is not simple. It's not incredibly overly complicated like anything that has legal and regulatory aspects, but it's also controversial. Why is it controversial? Because first of all, many believe that NIL is insufficient compensation for college athletes whose labor and NIL mean billions in media revenue for the colleges and for the NCAA. Question is whether or not athletes should be paid as employees, which right now they're not. Many believe that NIL failed to address the inequitable distribution of media revenue where coaches and athletic departments get millions. Recently, the college football coach of LSU was fired, and his contract provided for something like $54 million as a termination contract if he leaves. That's in litigation right now, but the coaches are getting paid significantly high money as employees, where the players who are putting their talents and labor and life at risk and playing a very hazardous game initially weren't getting anything and are still not getting paid by the schools. NIL deals, except for this recent House case, come from third parties and not being paid by colleges. And we can talk about that further. On the other hand, the NCAA, who's had it very good prior to 2021, is seeking to regain control over the players. They are seeking promotion of what's called the SCORE Act, which is seeking federal preemption of state NIL laws. That act, which was moving forward in Congress, just got kicked out of Congress, where it's not going to be moved forward in this term. But in the meanwhile, the NCAA is also knocking on President Trump's door, who has also mentioned that there should be a cap on NIL deals. Next point is concern over the ability of colleges to pay for the escalating cost. NIL is not cheap, where prior to NIL, colleges and universities and NCAA was getting free labor. They're now having to pay, and there's also increased expenses and increased legal liability as a result of this NIL. And clearly, a lot of people don't like that. There's also Title IX concerns in that there is a disparity between men and women's NIL deals, in that usually the high revenue male sports of football and basketball get the greatest NIL deals, where some of the women's sports, even though women's basketball is doing much better, they're not being equally compensated in NIL deals. And then lastly, there's a little bit of racism and sexism. Some people in this world don't like seeing young Black men and women of both races become millionaires. And so there's a lot of racism and sexism relative to NIL deals. Let's move on to the next slide, please. Thank you. So why does NIL matter beyond simply the rights of college athletes? So the question here is NIL a right that is limited to high school and college athletes? And its basis is the right of publicity, which is not limited to athletes. The right of publicity really protects every person. Every person has the right to their privacy. And Louisiana statute is an example of the right of publicity relative to state law. However, notwithstanding the fact that the right of publicity is available for everyone, there's not a broad NIL law that protects everyone. You kind of wonder why not, and it's just that it hasn't happened. So arguably, everyone is entitled to potentially become an NIL millionaire. For example, Kaylee Lane, whose picture is in the corner, is a 25-year-old social media influencer who's known for his silent, sarcastic videos. His net worth is in 2025 is approximately $40 million, which has been the result of basically NIL, not a college athlete, a non-athletic, kind of social influencer getting paid big bucks for NIL deals. I argue that NIL law should be based on the fundamental right of property and contract laws, which would protect every person, giving them a right to benefit from their NIL and not just limited to college athletes. Let's move on to some of the basis for that. So my argument is that NIL should be viewed as the natural property of every person, not only college athletes. And that's based on a number of our basic foundational principles and constitutional principles, including John Locke's theory, which says every man has a property in his own person. This nobody has any right to but himself, John Locke. The Declaration of Independence, as you know, referenced life, liberty, and the pursuit of happiness. That happiness actually was a code word for the word property back in those days. Property is an essential component of individualized freedom. And then lastly, relative to constitutional principles, in a very important copyright case where a person was trying to copyright the term Trump's too small, that failed. The Supreme Court, and Justice Thomas writing the majority opinion, says this: the history and tradition of restricting trademarks containing names is sufficient to conclude that the name clause is compatible with the First Amendment. Which that basically means is that everyone has power and control and a property right over their name, image, and likeness, and not just college athletes. Let's go to, I think, the last slide. So this is a summary slide, and then we'll move to our breakout sessions and then the Q&A apologize for the lecturing, but I'm glad that you're here. And let me summarize what this is all about. So NIL means that since 2020, college athletes have the legal right to become NIL millionaires. NIL refers to, number one, endorsement contracts for social media influence. Number two, booster deals for playing for a particular team. And three, recently direct pay for play from a college. Three, NIL represents a fundamental shift in college sports, empowering athletes with financial opportunities, subject to many legal and regulatory controls. NIL is controversial, with many saying it's not enough, while others say it should be abolished or severely restricted. As NIL relies on contract law, players and their families should employ a seasoned NIL contract lawyer to protect the player's interest. And lastly, NIL should be viewed as a property right that entitles everyone with the power to benefit from the use of their personal identifiers or attributes. Thank you very much for listening, and I look forward to your questions and conversation in the chat, in the breakout session.
Thank you, Mitch. That was wonderful. As usual, you took it's complex to me, maybe I'm just not that smart, but a complex topic, and you sort of, simplified it for us, which is the point of our What Do We Mean By series. I'm going to